with that, taking the summit forward right now here at the Legal Era 7th Annual Bankruptcy and Insolvency Summit. Time now for us to take things forward with our next session. Now, in the next session, we have something very interesting lined up, as this is going to be a session here for the important panel on mediation under the Insolvency and Bankruptcy Code 2016. And yes, for the session to present some very important insights with respect to looking at mediation under the Insolvency and Bankruptcy Code 2016, where we're going to be looking at the scope of using mediation under the code, unique challenges, the pre-commercial mediation, amongst others. Without further ado, let me invite on the very important panelists and speakers for the session. The session shall be moderated by Tejas Karya, partner Shardul Amarchand Mangaldas Corporation. Tejas also heads the firm's arbitration practice. His expertise spans across international and domestic commercial arbitration. He has represented in arbitrations before LCIA, ICC, ICA, amongst others. He has advised on the drafting of amendments to a number of key acts, including Indian Arbitration and Conciliation Act 1996. Meanwhile, as Tejas sir joins us, Tejas Kalia sir is just joining amongst us. He is being represented by Aloykita Rajviji. So we welcome Aloykita Rajviji. She'll be moderating the session. A warm welcome to our moderator, Aloykita Rajviji. And with that, ma'am, with your consent, I call on the distinguished panelists for the session. So moving ahead, we are delighted to welcome Justice Arjun Kumar Sikri. Justice A.K. Sikri, he is former Judge, Supreme Court of India, and with excellent academic record, Justice Sikri has conducted cases of all types, his specialization in arbitration and commercial matters, constitutional cases, labor, service matters, amongst others. He has been counsel for numerous public sector undertakings, banks and financial institutions, various private sector corporations. He has also been an academic faculty at the Campus Law Center, University of Delhi, Vice President, Delhi High Court Bar Association, member of governing body of several colleges, and also became the acting Chief Justice of Delhi High Court in 2011 and elevated as Chief Justice of Punjab and Haryana High Court in 2012. And Justice Sikri was elevated as Judge Supreme Court of India in 2013. So warm welcome to Justice A.K. Sikri. We are delighted once again to have amongst us Dr. T.K. Viswanathan, Chairman, Bankruptcy Law Reforms Committee. Dr. Viswanathan, as we all know, is a legal luminary who has been awarded with the distinguished Padma Shri by the President of India. He has held various important positions in academics, Government of India, the Lok Sabha, and during one great 4 decades of his career, he has served as a lawyer, a professor of jurisprudence, Secretary to Government of India in Ministry of Law and Justice, and Secretary General of the Lok Sabha. He has drafted many landmark legislations over the past 2 decades, and government has also indeed immensely benefited from his expertise. Once again, sir, greetings and welcome. We welcome Mr. Sandeep Bajaj, founder and managing partner, PSL Advocates and Solicitors. Mr. Sandeep Bajaj has been spearheading PSL, which is a very renowned and leading law firm with head office at Delhi and other offices at Mumbai, Chandigarh, along with a reference office in China, and has team strength of 40 and more legal counsel. Mr. Bajaj regularly advises big corporate houses in India in respect of disputes involving billions of rupees, and under his leadership, with consistent efforts with his other partners, the firm has indeed done incredibly well. So warm welcome to Mr. Bajaj. Welcome, sir. We welcome Mr. Vijayendra Pratap Singh, partner AZB Partners at AZB and Partners. Mr. Vijayendra Pratap Singh, he heads the litigation at AZB and Partners Delhi. He has spearheaded various arbitrations pertaining to validity of shareholder agreements, options contract, long-term supply, amongst others. He has also represented SEAT in the Balco case before the Supreme Court of India on the scope and extent of judicial intervention of Indian courts with foreign treaty arbitrations. And this is one of the important achievements that comes with the great and wonderful profile of Mr. Vijayendra Pratap Singh, partner AZP and partners. So on that note, time now for us to get into the brainstorming for the very important session wherein we will be learning on important dynamics and inputs concerning the mediation under the Insolvency and Bankruptcy Code. I would request our moderator, Madam Rajvi, to take it on from here. Once again, greetings and warm welcome to everyone. And I hand it over to our moderator. Ma'am, please.
Thank you, Dr. Amna. A very good afternoon to all the panelists and attendees. My name is Avalokita Rajvi, and I'm with the Disputes and Arbitration Practice at Shardul Amarchand Manudas. Due to some exigencies, Mr. Karya, who was originally going to moderate this session, will be joining us in a short while. And in his absence, I'll be moderating today's session. It's my absolute pleasure and honor to be moderating today's panel discussion on the topic, mediation under the Insolvency and Bankruptcy Code 2016. Mediation is one of the most popular modes of alternate dispute resolution in India. Parties to disputes in India have shown an increasing preference for mediation as compared to traditional litigation in Indian courts, which can be time-consuming and entail significant costs. India has taken a significant interest in promoting mediation through various legislations. Examples which would include Section 89 of the Code of Civil Procedure, Section 12A of the Commercial Courts Act, and Chapter 5 of the Consumer Protection Act. Presently, the mediation bill, which has been introduced in the Rajya Sabha in December 2021, is the most awaited development on the law on mediation in India. While a comprehensive law on mediation in the form of a bill is still awaited, the law on insolvency and bankruptcy in India is governed by the IBC. The IBC has been hailed as one of the finest economic laws and has largely achieved its objective of promoting entrepreneurship, corporate reorganization, and insolvency resolutions in a time-bound manner. In this panel discussion, we'll be discussing the prospects of using mediation to resolve insolvency disputes in India, the scope of using mediation under the IBC, pre-commencement mediation in insolvency disputes, legislative changes required to adopt mediation under the IBC, and the unique challenges in using mediation under the IBC. I warmly welcome and thank the panelists for being available for this panel discussion. Moving on, there has been recently a lot of discussion about using mediation to resolve insolvency disputes. We will start this session by discussing the scope and ambit of using mediation under the IBC. My first question would be to Dr. Vishwanathan. So, what advantages does mediation offer for resolution of insolvency and bankruptcy disputes as compared to traditional litigation or any other forms of ADR?
Actually, we already pointed out the cost and time factor. They're the main advantages. But I see one size does not fit into every type of a stakeholder. You see, the advantages of mediation over other forms depends on who triggers insolvency process. Let us see. In a corporate insolvency process, it's a financial creditor who is in an advantageous position. And he's in a great hurry to realize his work because time delay causes attrition, value loss. So he may not show much interest in going through this mediation process, which means he thinks is a delaying process. And if the affected person files for a corporate debtor files for insolvency, I think it doesn't make sense for him to go for mediation. He could have done it earlier also. The only person who will stand most benefited by this in the corporate insolvency process is the operational creditor. Here he can have a great advantage, and this is where mediation can play a very useful role. I'm not sure whether I'm right or not, but this operational creditors is where mediation can play a very crucial role. But another part, apart from corporate insolvency process, mediation has a very big role to play when we bring into force the personal insolvency part of the code. Because in personal insolvency, it's going to affect everybody cutting across their life, I mean, their status. Everybody is going to be affected by that. And then nobody wants to be dragged to a court for something which they are not aware. So the advantages of mediation will be very high in the case of personal insolvency. And then we are already moved in towards the electronic format of courts or tribunals are ready to hear electronically. You'll see the subsequent amendments to the Debt Recovery Tribunal Act has already made these debt recovery tribunals compliant with virtual courts. These amendments, I don't know whether it's been given effect to, but they are ready to take on online hearing and other things. So we like to emphasize upon online mediation. That is where things will definitely help. Because Section 19A, which has been introduced in the Debt Recovery Act, provides for electronic filing of all documents. Then the tribunal has to have a website, dedicated website, and publication of the judgment on the website is deemed to be a public notice, etc., etc. So we are ready for a virtual court hearing. So we need to have online mediation now. Now you touched upon this legislative changes which are required. You have referred to the mediation bill which is pending before Rajya Sabha. Now, this mediation bill is a very ambitious project which has been brought in, and it takes out this mediation conciliation part from the Arbitration Act. The whole thing is knocked out, and we have a standalone law right now. Now, what you see, it is necessary for us to look into this mediation bill because it affects us in the IBC in a very big way, but it has not been taken note of. All other acts have been taken concern, but IBC has been left out. I'll just flag some issues on this. If you permit me to talk now, or I can talk later. Should I continue now, or can we hear the others?
So we'll be delighted to hear your views, sir.
Okay. Now, see, Section 2 of the mediation bill, which is pending, you referred to, is an overarching bill which applies to everything. It says, subject to the provisions of subsection 2, this act shall apply when mediation is conducted in India, and all or both parties habitually reside in or incorporate in or have their place of business in India, one, or the mediation agreement provides that any dispute shall be resolved in accordance with the provisions of the Act, or there is an international mediation. So it is a broad, oversweeping application. But subsection 2 provides an exception in a limited way to the government entities, but it says in commercial matter it does not apply, still mediation will apply, and the government can always grant exemption. So they are very cautious in moving when the government is involved. No, then Section 7, it provides a mediation under this act shall not be conducted for resolution of any dispute or matter contained in the indicative list under the first schedule. And in the first schedule, the government can next notify the amendment, etc. What are the amendments? Let us see. There are a lot of things, any investigation, inquiry, etc., proceedings before appropriate commissions, appellate tribunal, electricity, proceedings with the Petroleum Natural Gas Commission, proceedings with security SEBI, and land acquisition matters, etc., etc. A lot of exemptions are there. Then we pass on. I'm pointing out because I am concerned about how do we bring in IBC here. Then Section 56 provides, subject to the enactments mentioned in the second schedule, the provisions of this act shall have overriding effect. No, this is the overriding effect over other laws, including IBC, for conduct of mediation or conciliation, notwithstanding anything inconsistent there, etc., etc. So it is an overriding provision over all the laws. 56. What are the enactments mentioned in subsection 2? Let us see. Second schedule, which provides for the exceptions, the Industrial Disputes Act, the Brahmaputra Board Act. I don't know why they brought this thing there. Cine workers, cinema theatre workers, Regulation of Employment Act, then Family Courts Act, the Maintenance of Welfare of Parents and Senior Citizens Act, the Sexual Harassment of Women in Workplace Prevention Act, then 8, Finance Act 2016, and 9, the Industrial Relations Code. So, see, these are the acts which have been said where mediation have no place. So that has been listed out. Probably the government will amend and add more acts. No, it has amended many acts, and it has amended in Consumer Protection Act, the Commercial Courts Act, where you referred to Section 12A as provided for pre-litigation mediation and settlement, etc., etc. Now, these are all things I am only concerned about one thing, where Section 442 of the Companies Act has also been amended. In the Section 2, it says the Companies Act shall be amended like as shown in the 8th schedule. In the companies, I read out this for your section. For Section 442, the following section shall be substituted. Reference to mediation. Any of the parties to proceedings before the central government tribunal or appellate tribunal may at any time apply to the central government tribunal or appellate tribunal, as the case may be, in such form as with such fees as may be prescribed, for referring the matter pertaining to such proceedings and mediation, and the central government tribunal or appellate tribunal, as the case may be, shall refer the matter to mediation to be conducted under the provisions of the Mediation Act. Now, I am not very sure the tribunal is constituted. IBC tribunals are working under the Companies Act. I am not sure whether this 442 applies to them. This section will apply to them. And so we need to tailor the mediation bill to our requirements. And I see another issue here, online mediation. There is a proposal to create a council, mediation council, who will prescribe regulations, specify regulations for conduct of mediation proceedings on online. And in all those matters, we need to have the IBBI, Bankruptcy Board of India, getting involved in this, in the framing of the regulations or in consultation, etc., because mediation of IBC disputes are very specialized. It's not like any other kind of mediation where you can compromise, where you can negotiate or do things. People have to be well versed with economic matters. They should have awareness of market conditions. They should be able to speak and convince with figures, economic figures, market figures. So this is something which we have to take note of, and we have to, this is before the committee, and people should go before the committee and come up with suggestions. This is what this occurred to me initially. As far as online mediation is concerned, as I told you, when personal insolvency is being implemented, is brought into force, you will have a lot of problems before the debt recovery tribunal, where here online mediation can be a great boon. And it is here mediation will play a very substantial role for the common man. Thank you.
Thank you, sir. The next segment of the panel discussion will focus on pre-commencement mediation. Pre-commencement mediation refers to undertaking the process of mediation before the commencement or institution of any formal legal proceedings before courts and tribunals. So my question is to you, Mr. Bajaj. Under the present Indian legal framework, is pre-commencement mediation envisaged for insolvency and bankruptcy disputes?
Thanks, Avalokita. First of all, if I can just straight away answer that, we'll not be able to find any provision in the Insolvency and Bankruptcy Code where it provides for pre-commencement mediation. But having said that, if I can just provide some reasons also, though I fully agree with Dr. Vishwanathan also that mediation is an effective way. But I beg to differ on and especially want to highlight some different aspect of this issue. Because when we talk about the mediation, what we refer is the settlement of disputes. So we always imagine there are disputes which needs the mediation process. And when we go to the Insolvency and Bankruptcy Code, what we see is if there is dispute, there cannot be any insolvency. Insolvency comes into picture when the company has already reached to a state where it is on the verge of becoming insolvent, they are unable to pay their debts. So in that context, if we consider that once proceedings under insolvency are proceedings in rem, as contrary to proceedings in personam in respect of other acts. So that's the reason Insolvency Code provides for a strict timeline also, especially for admission. We have seen that only 14 days time period is provided to admit the petition, though of course definitely that's not mandatory timeline, but somewhere it shows the intention of the legislature that they want it to be expedited, where there is a need to resolve the insolvency at the earliest instance to protect the substratum of the company. So even imagining that the Mediation Act is there and it doesn't provide the insolvency, as well as insolvency code doesn't provide for pre-commencement mediation, that may be one of the reasons, because insolvency we are trying to resolve here. We are not trying to settle the dispute between the party, like Dr. Viswanathan has also mentioned about the operational creditor. Yes, definitely. What we have seen is, in case of the financial creditor, and in case where the corporate debtor itself going for the insolvency, there is a little scope for mediation as such, because financial creditors, their debt is huge. At that stage, they have already tried everything, and at last stage, they are reaching for insolvency. But in case of operational creditors, we have seen the examples where almost after the admission stage also, around 30-40% disputes have been settled there and the application has been withdrawn. But when we say that here the company petition has already been admitted, and before that, even if someone is able to show the dispute, then of course, pre-existing dispute, the insolvency petition cannot be admitted. So another aspect which we need to consider here is whether it is gonna be helpful by delaying it a further period of 2 to 3 months for mediation, like what happened in a Commercial Courts Act. The experience has not been that good. In Commercial Courts Act also, only 1 or 2% cases are getting settled at the pre-commencement stage. So in insolvency, if we apply there where we already talk about that there is no dispute, we don't envisage actual dispute between the parties, though everyone tries to raise the dispute and say that this petition should not be admitted. But if they are successful, in any case, the company is not going into insolvency. So those aspects, I think, when insolvency code, of course, when it was incorporated also, these aspects must have been behind the reason that this kind of provision has not been provided. And in Mediation Act also, this is not provided. So that's the view which, of course, I consider that is required to be considered while discussing the mediation under the Insolvency and Bankruptcy Code.
Thank you, Mr. Bajaj. Adding on to the same, to another question under the same theme of pre-commencement mediation, my next question is to Mr. Singh. Sir, would the requirement of mediation before the commencement of insolvency proceedings contribute towards improving the speed and efficiency of the insolvency resolution process, or would it prove to be counterproductive?
So thanks. The best part about following Dr. Viswanathan is that he lays down a fabulous foundation. So you just have to bounce off that foundation. So let me just start with the fact that there is already some amount of enabling mechanism available. The question is not of whether there is specific permission, but is there a will and is there a need for it? And where there is a will, there is always a way. So if I see the IBC, I see Section 12A as being something which facilitates mediation without calling out to mediation. Because it says that after a tribunal admits or the adjudicating authority admits a petition, you have the ability to withdraw that petition if 90% of the creditors or the committee of creditors agrees. And the person who has triggered it is also aligned to it. And this only happens when people are able to chat, not go to a court and find a commercial solution. And somebody alludes to that, saying that commercial operational debt has been resolved in that manner quite significantly. So A, it does work. B, not only does it work, it actually works because what is it that IBC seeks to do? It's not adjudicating anything, it is resolving something. And where what is important is the commercial wisdom. So the IBC's idea is not to get mad. The IBC's idea is to get even. And when you're looking at it from that mentality or that mindset, where you're looking at a commercial wisdom, there is always a win-win. And a mediation-based paradigm squarely fits into that. Because a mediation-based paradigm is non-adversarial. Nowhere else will you find it fit better than in a process where you're actually allowing people to find their solution. The third piece that you can see is the fact that it preserves the ability to maintain relationships. So in case mediation is used as a via media for the purposes of resolving disputes, etc., you have the ability of, say, the committee of creditors speaking with each other. You have the ability of the committee of creditors using, say, the COC meeting to look at and vote on things, including whether or not to accept a 12-way proposal. So in such a situation, you have a say in what you want to get, you have a part in the solution that you want, and you decide what you can live with. And if mediation provides you these three pieces or precedents, then all you need is the springboard. And Dr. Vishwanathan correctly points out that there is something in the Companies Act. Now, it is up to people to use it under Rule 11 or use it as a part of what we've seen courts do, extend it under the concept of justice, equity, and good conscience. That's how the Transfer of Property Act was extended to areas where it didn't otherwise apply. And if we don't do this, we will walk into the same problem that the government seeks to obviate and end through the use and its push towards mediation, which is pendency in courts. The same pendency quite as much exists with the adjudicating authority today. I've had a chance to go before the Parliamentary Committee, Standing Committee on Finance on this, and their report of 4th of September is quite telling in terms of the fact that they realize that the idea is a great idea, but the institution and the infrastructure to facilitate that idea is going to be something that needs to be reinforced. So how do we reinforce that? Now, we can't take into appointing people because that's something that's solely in the remit of the government. We can't go into getting more cases listed or benches set up. So what we can, however, do is cut down the number of cases that need to go to the bench. And that's where mediation serves as an effective filter. It ensures that only those where people are not mad and are looking at an economic, effective and efficient solution can be resolved. They get a platform where they can do it. And unlike the pre-institution mediation of the Commercial Courts Act, where there is no sufficient deterrent, the IBC has told everyone that winter is coming, which means your company is going to be lost and 29A is going to ensure you're never going to be in the company again. Therefore, the deterrent and the effective stick to a promoter is a lot more here than it is under the Commercial Courts Act. So if we have the right mindset, we have the way, we will find tools to ensure that this idea is an idea whose time has come. We will be able to take it to not only find solutions for the corporate debtor and generally the economy, but we'll also find solutions towards meeting those cases which are hanging in the pipeline, finding an answer for them, either by way of using this mediation as a method, as an alternative method for resolution, not a precursor, but a real alternative, or getting them to get heard because where this alternative fits, those don't clog up the pipeline anymore. So according to me, it's an idea whose time has come and it's a no-brainer that we should use it, find a commercial solution, because if commercial wisdom is good at the end, commercial wisdom and timely commercial wisdom is definitely better in the beginning. Thank you.
Thank you, Mr. Singh. One of the themes that we are grappling with today is that the IBC presently does not contain any provisions on mediation or any other form of alternate dispute resolution. Therefore, it becomes very important to discuss the legislative changes which are required to be introduced in the framework of the IBC. So, Dr. Vishwanathan, my next question would be to you, which is, should the IBC be amended to provide for mandatory institutional mediation for the resolution of disputes covered under the IBC?
No, as I told you, I am not for mandatory reference to mediation for all cases. And I told you it is going to work well only with the individual insolvency, personal insolvency, and in corporate insolvency, it will only delay the process because time is very sacrosanct, and you should leave it to the option of the parties, or maybe you can leave it to the discretion of the tribunal. I am not for mandatory reference to mediation. It will become a procedural formality. But for individual insolvency, I think people will resort to this in a very big way. And this online mediation and institutional mediation will go a long way in addressing the common man's problem. So I don't think in corporate insolvency process, this is going to have any great effect in reducing backlogs or anything. I'm not for mandatory mediation in corporate insolvency process.
Thank you, sir. While mediation is an effective dispute resolution mechanism, it has not been very widely used in India in the context of insolvency disputes. And as such, providing for mediation under the IBC is bound to create some unique challenges. Mr. Bajaj, given that mediation is not statutorily incorporated under the IBC, what are the various challenges which you foresee in providing for mediation under the code?
Avalokita, see, first thing, let's see that this is an economic law, and we always see that this is not a normal dispute between the parties, and this is not something where the family dispute is going on, or where the mediator can simply sit and try to resolve the dispute. This is a special law where a lot of expertise is required. So first challenge actually we always find is that the trained mediators are really required for this kind of thing, even if we try to explore it. So that challenge will definitely be there, because otherwise the whole purpose will be defeated. Parties may take the benefit of this just to delay the proceeding further, instead of taking the benefit of this. What we have seen in NCLT also, every day the matters are lingering on because of the, definitely there is a problem in infrastructure. That's one part, but the parties also, if I am appearing for, I'm representing the corporate debtor, always there is an attempt that if the matter could further be adjourned, or it could be simply be postponed for one reason or the other reason. So that should not be, that's the first thing actually. We need that the proper trained mediator must be there. If the mediation, he should see it in the first instance itself, that whether there are chances of mediation of settlement, only then the party should proceed. Otherwise, simply refer the matter to NCLT. That's number one. Number two, what we have seen is in several judgments, even Supreme Court in Bharat, High Court, high-tech judgment also, the law is very settled. Today, what the NCLT needs to see is debt and default. Even NCLT today cannot ask the parties or refer the parties to settlement. So if we see that if we want to incorporate that, we'll have to change the law extensively, especially the corporate insolvency resolution process is concerned, or for that matter in the personal guarantee. The only jurisdiction given to NCLT is to check the default, and within 14 days, they'll have to see that and immediately refer it either to admit it or to reject it. There is no third option which has been given to the NCLT. So all the aspects needs to be considered. Third is definitely time constraints. This is not something where we are saying that we have the luxury of time. In Commercial Courts Act, it's a 3 months time period is given for mediation, and then 2 months it can be extended. But in insolvency, those kinds of things or luxury of time is not there. We'll have to immediately take the action. If the matter is not getting settled, then definitely it should immediately be referred to. And another challenge actually what we need to see is in case of whether there is a financial creditor who is approaching the NCLT, or it's an operational creditor, or the corporate debtor. As I've already said, that the corporate debtor, when it's approaching, it itself agree that there is a need to resolve the insolvency. There is no need for referring the matter to the mediation. But when there is a question of financial creditor also, we have seen when most of the time financial creditor approaches the NCLT when the CDR has failed. There is already a corporate debt restructuring attempt which has been made. That has already failed, and debts are huge. In those scenarios also, especially in a corporate insolvency is concerned, there is a challenge that whether pre-commencement mediation is required to be provided. Yes, definitely there is a scope for operational creditor, but again, I'm saying that operational creditor are the small creditors. That's number one. Number two, operational creditors, there is a mandatory notice which is required to be served in this case. 10 days notice is definitely provided. If someone approaches immediately and say that I'm ready to settle the matter, then there is a little bit scope where the parties can be referred to the mediation to resolve the dispute. Otherwise, the NCLT can straight away proceed to hear the application and decide the matter. So, and third thing is in respect of the personal guarantors. Yes, definitely. Dr. Viswanathan has rightly pointed it out. That's where the mediation can really work effectively. Because I'm not talking about, when we talk about the personal guarantor, then we'll have to see whether they are the guarantors to the corporate debt or this is the direct debt which has been taken by them. In case of personal guarantor, there is again a same problem what the corporate insolvency resolution process is concerned. But when there is a personal debt of individual insolvency is initiated, there definitely mediation is a way to look at it. There is an option to explore that, because in case of personal debt, again, the amount will be less. And instead of declaring a person bankrupt, it's always better that there should be a chance given to him to mediate the dispute and settle the matter. So these are the challenges which we need to see before even proceeding for this pre-commencement mediation. Thank you.
Thank you for your remarks, Mr. Bajaj.
Thank you.
My next question is to Mr. Singh. So what are the various steps that can be taken to ensure that mediation in insolvency disputes is conducted in a time and cost-effective manner?
So I'll put it to two simple parts there. The first part is, where do you do it? So rather than pre-institution, once instituted, without a standstill, run the process. Initially, you would run it till the point of the EOI being solicited. So that could be a good place, which is after the COC is set up and before the EOI is sent out. You can give the corporate debtor a chance to try and figure out A, who to negotiate with, and B, what is the amount that has been given collectively. So it's effectively similar to a crampdown which happened under US law, where you are looking at collective bargaining, because our 12-way system encourages collective bargaining as opposed to individual settlement. That's one place where you can have it. The other place where you can have it is in respect of not just the insolvency, but at times with respect to another aspect of insolvency, which is the vulnerable transactions under insolvency, the preferential, undervalued, exorbitant, and the wrongful trading transactions. Now, these are transactions which may get more litigious, but are nonetheless another form of recovery. So if you are looking at something there, if one were to take a look at the model timeline, in terms of the model timeline, the application needs to be filed by about day 135 under the timeline. While the timeline is directory, it would be a good time to have this conversation with people, with the proof shown to them. And if there are third parties who have bought assets and have bought assets believing that they are entitled to those assets, give them a chance whether they want to buy peace. And this is something that will run in parallel without calling for any standstill on any of the proceedings. If settlements are entered into, those settlements can be proceeded and placed before the adjudicating authority for the purposes of their blessings or the baptism of that settlement as a finality and the end of the clawback process against those people. But the most important thing that you will need is to recognize the nature of the beast that you're dealing with. You're dealing with financial creditor debt, which is the largest in our system. And largely, a large part of our financial creditors are, in fact, public sector banks. For them to settle anything, you need to have some kind of a facilitating system. Because otherwise, each one of them is facing what I call the fear of the 3 Cs: CAG, CBC, CBI. So no banker is going to touch mediation unless there is something which actually says that this is kosher, this is court-driven, and therefore it is complete and comprehensive. So I think what you will need is not just a change in mindset. The areas where you can incorporate it can be identified, but most importantly, you need to have a facilitative mindset where it does not lead to more problems to the people who are going to sign off, because someone has to sign off on that document, right? And that person needs to be sure that once they sign off, they will not go to jail. They will not be adversely commented upon, therefore have their disciplinary record violated. And last but not the least, can be held responsible for the fact that they signed off some money. So that, I think, is the change that you will find. And you can identify at which stage and what kind of percentages are they looking at. Standard recovery as per the standing committee's report is about 40%, 40 paise to the rupee right now. You can have anything which allows for a longer amount or a larger amount, something in the nature of 50 to 60% to be a threshold that can be prescribed. It will give the bankers a certain degree of comfort. It will be higher than the average. It will be about 100% or 50% higher than what your average is. And you can keep moving this depending on how the average moves up. So these are some changes that can be brought about. Some of these are actually changes in the nature of regulations that can be brought about now. Others are in the nature of what you would call in the nature of policy, which can be done. And the government can best help itself by coming out with a national litigation policy, which will allow for a small chapter on insolvency. It will take care of, at least amongst other things, our issue with respect to the tax department coming belatedly and making claims. So all those can be resolved in an effective and an efficient manner. Thank you.
Thank you, Mr. Singh. We are also joined by Mr. Tejas Karia. Thank you, sir, for joining us.
Thank you. Sorry, I got a bit late in Supreme Court, so my apologies.
Sir, continuing the discussion on the panel here, my question to you, Mr. Karia, is that how can mediation be used to resolve cross-border insolvency issues?
Thanks, Avalokita. Good afternoon, everyone. See, what we have seen is that insolvency has been an issue which has been alternate dispute resolution methods are being used for example, mediation. But when it comes to cross-border insolvency, it throws up completely new challenges. There are various issues which get involved. One is that there are different laws which can be come into effect. Then we have different jurisdictional courts, and the insolvency proceedings in all those different jurisdictions can pose different challenges. When we talk of mediation, that could be the best way to resolve cross-border insolvency issues, because what happens in the mediation is the mediator has an ability to try and see that if the parties can come to a negotiated settlement, and then what outcome could be that you can avoid the complete process of going to different jurisdictions and trying to resolve the disputes in different processes. What has happened world over is that there are a number of cases which has examined this issue of cross-border insolvency. In fact, the UNCITRAL model law also has spoken about that, and India is trying to bring that in the draft mediation bill 2021, because what happens is that in the mediation bill, the model law and mediation bill which is proposed now will make the cross-border insolvency also amenable to mediation. If we talk about foreign jurisprudence, the cross-border insolvency has been recognized in various cases. In Olympia versus New York, where the insolvency proceedings had commenced in both the US and Canada, a mediator was appointed to harmonize the Canadian and US proceedings and bring about a consensus among the parties regarding the corporate governance issue. In Lehman versus Maxwell Communication also, the mediation was very useful in cross-border insolvencies and the determination of the complex claims where there was a divergence and uncertainty of legal position. In the bankruptcy of Maxwell Communications, the proceedings were commenced in both US and UK, and an examiner was appointed to mediate and resolve conflicts amongst the jurisdictions, and ultimately to develop a coordinated plan and scheme that harmonize the US and UK insolvency law. So what we have seen is that the mediation in cross-border matters is very important, but India has to come up to speed with the foreign jurisprudence. It is still in the infancy stage, and there are reports which find new ways to devise an effective framework in India for cross-border insolvency and establishing a mediation as the means to resolve the cross-border insolvency. And in light of already existing mechanisms, such as the UNCITRAL model law and mediation bill 2021, we need to ensure that once we have the systems in place, the benefits of mediation can definitely be used for cross-border insolvency as well. Thank you.
Thank you, sir. Sir, I have another follow-up question. We were discussing pre-institution mediation a while ago, so I have a question on that for you. As per Section 12A of the Commercial Codes Act, pre-institution mediation is mandatory except for when the suit contemplates urgent interim relief. In your view, sir, Would a similar provision be feasible for insolvency disputes, or are there any other considerations to bear in mind?
Yeah, that's an interesting question. What happens with regard to Section 12A of the Commercial Courts Act is that it provides that the suit which does not contemplate any urgent interim relief shall not be instituted unless the plaintiff exhausts the remedy of the pre-institutional mediation. This mandatory nature of Section 12A has recently been confirmed by the Supreme Court in Patil Automation versus Rakeja Engineers. But the only exception to the mandatory pre-commencement of the mediation provided under Section 12A of the CCA is where the suit contemplates the grant of any urgent interim relief. Now, for determining whether such requirement should be introduced for insolvency dispute under the IBC, we have to refer to the Mediation Bill 2021. Now, Section 6(1) of the Mediation Bill provides that whether any mediation agreement exists or not, any party before filing a suit or proceedings of civil or commercial nature in any court shall take steps to settle the dispute by pre-litigation mediation. The use of the expression shall denotes that the pre-litigation mediation is a mandatory in nature. Now, despite providing for mandatory pre-commencement mediation, the Mediation Bill also contemplates allowing parties to seek urgent interim relief under Section 8(1) of the Mediation Bill, that only under exceptional circumstances exist, the party may, before the commencement of or during the continuation of the mediation proceedings, file suit or appropriate proceedings before the court or tribunal having competent jurisdiction, seeking urgent relief. Therefore, while permitting parties to seek interim relief, the Mediation Bill does not seek to do away with the requirement of the pre-commencement mediation. And therefore, if we take a cue from the Mediation Bill, the IBC may be amended to allow the parties to seek interim relief, even where the dispute has been mandatorily submitted for pre-commencement mediation. And therefore, a provision such as Section 12A may not be most feasible option as proceedings for interim relief and mediation proceedings can be proceed simultaneously. So just to sum up, is that for IBC, we need to have a proper amendment so that they can seek interim relief when as and when required, and the mediation should not be as a precondition for that. But in all other cases, you can definitely go to mediation if there is no urgent interim relief is required.
Thank you, Mr. Karya. Having heard the very enlightening remarks from our esteemed panel, we would now like to open the session to questions from our attendees. So our attendees are requested to post their questions in the chat box, and we'll be happy to pose them to the panel. I'll invite any questions from the attendees.
I think all answers were quite clear. So.
Okay, that's, I think, the cue to conclude this session. With this, we come to the end of this panel discussion. I warmly thank the panelists for taking out the time to share their valuable inputs. The issues discussed today are very relevant and will be at the forefront if the IBC is amended to provide for mediation. Many important suggestions have been made during this panel discussion in respect of the scope of using mediation in insolvency cases, legislative amendments to provide for mediation under the code, and how to navigate the unique challenges that will arise if mediation is introduced in the framework of the IBC. Adopting some of these suggestions in the form of legislative amendments will certainly help in improving the resolution and disposal of insolvency disputes in India. I heartily applaud Legal Era for organizing this panel discussion. Thank you and have a great day.
Thank you.
Thank you very much.
Thank you.
For such important inputs, significant insights, amongst others. And without further ado, here at the 7th Legal Era Annual Insolvency and Bankruptcy Summit, time now for us to go forward with our next very interesting panel discussion. And as you all know, that's been a day-long session, a power-packed virtual gathering where we are addressing, sharing perspectives, and understanding new developments that we must understand with respect to India's path-breaking economic legislation, the IBC.